On November 1st, 2004, the Robert H. Jackson Center was privileged to have in its midst Professor Jeffrey D. Hockett of Tulsa University, one of only 3 authors who has written a book on Justice Robert H. Jackson. He spoke on his book entitled New Deal Justice, the Constitutional Jurisprudence of Hugo Black, Felix Frankfurter, and Robert H. Jackson. He spoke at both the Jamestown Community College and the Robert H. Jackson Center. However, we were blessed that he permitted us to interview him concerning the subject of his book and Hugo Black, Felix Frankfurter, and Justice Jackson. Please enjoy. For coming to Jamestown, New York.
My pleasure.
New Deal Justice, the Constitutional Jurisprudence of Hugo Black, Felix Frankfurter, and Robert H. Jackson. And you say in the beginning, this book began as an analysis of the constitutional jurisprudence of Robert Jackson, a justice who unfortunately has not received his due in the literature of public law. Why do you think he has had virtually nothing written about him? You're, with this book, one of very few who've actually paid some intense attention to him. Why do you think that is, Jim?
One main reason why political scientists, probably the main reason political scientists don't pay attention to him is that political scientists tend to look for grand theories of judicial decision-making, generalizable observations. And so methodologically, political scientists are averse to focusing on particular individuals. But that doesn't explain why law professors who have nothing against looking at individual justices have not done work on Jackson. The explanation why law professors don't focus on, or have not focused on him, I think has to do with the fact that Jackson was not easy to categorize. And in the book I make the point, I call his jurisprudence, his constitutional jurisprudence, a pragmatic jurisprudence. So it's very frustrating for scholars to try to classify someone like Jackson. In the book I contrast him with 2 of his colleagues, Hugo Black and Felix Frankfurter. Those individuals, there's been an enormous amount written about both of them. Why? Because they are easy to categorize. You have Hugo Black, who is an absolutist when it comes to First Amendment jurisprudence, and with respect to the issue of incorporation, the degree to which the Bill of Rights are to apply against the states, he calls for total incorporation. All of the provisions of the Bill of Rights apply against the states. Then you have Frankfurter on the other extreme, who I refer to his jurisprudence as being a passive form of constitutional jurisprudence, where he calls for virtually no incorporation of provisions of the Bill of Rights to be applied against the states. And then with his First Amendment jurisprudence, he was almost entirely passive, deferring to the political branches on most First Amendment issues. Then you have Jackson in between the two. It's very difficult to categorize these with respect to incorporation. He calls for selective incorporation. Some, but not all, of the provisions of the Bill of Rights should apply against the states. And then his First Amendment jurisprudence, again, very difficult to categorize. He is not an absolutist like Black, and he's not passive like Frankfurter. And so I think scholars tend to shy away from justices who don't lend themselves to being classified readily.
You read Glendon Schuberts' book.
Long time ago.
And he did a sort of the behavioral analysis of justices generally, but was focused in one book on Jackson. What was your take from all of that?
From what I remember, I don't recall that Schuberts' book is an in-depth analysis of Jackson's jurisprudence. I think there is some introductory commentary, but it's primarily a collection of what Schubert regarded as Jackson's more famous decisions. And so, though Schubert ended up having an enormous impact upon judicial studies and the discipline of political science, I found when I was writing about Jackson that I didn't, and this is not a criticism of Schubert, because I don't think he intended his book to be an in-depth analysis of Jackson, but I wasn't able to use his analysis effectively to learn much about what made Jackson the justice that he was. So I ended up having to, and this is actually good for me, because had he answered all the questions, then there would have been no point to me writing the book. So I was on my own, essentially, to try to figure out what made Jackson the justice that he was.
Jackson's papers are principally at the Library of Congress. Did you have any reason to track down either Murray Gartner or Phil Kurland or any of those guys who, or Gene Gerhardt, who either had written a biography or had attempted biographies to sort of see what the pitfalls were?
No, I wasn't that smart about it. I just plowed ahead with what I read everything that I possibly could that people had written about Jackson, but I was under enormous time constraints as a graduate student, and just was left to my own devices and plowed ahead, and it was a very interesting experience.
What was the most surprising thing you learned because inevitably, well, I should back up. When you went into this project, did you have some preconceived notions about Jackson?
No, and that's, I think, was an advantage in that since really no one had looked at Jackson in depth, I had the understanding that most people did about Jackson, which was, I know he's an Associate Justice of the Supreme Court during a really interesting time. He was on the court with some of the most interesting and famous justices ever. He participated in some of the most important decisions in the 20th century, and I also knew that he was U.S. Chief of Counsel at Nuremberg war crimes trials. But on the whole, I did not have any preconceptions about Jackson. He was basically an enigma to me, and I will say that there was one view to which I was exposed, to which I felt compelled to respond, and that was the view of my mentor, Henry Abraham, who argued that there was a profound shift in Jackson's jurisprudence after he served at Nuremberg as U.S. Chief of Counsel. And in investigating further, I ended up, for the most part, disagreeing with Professor Abraham's analysis. In my book, I explain how one could reach the conclusion that Professor Abraham did. But if you scratch the surface a bit more, it appears that, contrary to Mr. Abraham's thesis, that Jackson went from being a radical libertarian to a deeply conservative justice, that he was pretty much the same before or after Nuremberg as he was before, which is to say he was not a radical libertarian before, nor was he a raging conservative after. In fact, this afternoon I'll be talking about Jackson's post-Nuremberg performance, and suggest that, if anything, what Nuremberg impressed upon him is the importance of the procedural protections contained in the Due Process Clause in the Fifth Amendment. So in that sense, you could argue if it had any kind of influence, it was a liberalizing influence on his jurisprudence. So.
Why compare him with Frankfurter and Black? Why not Douglas? Why not other justices? Why did you select those two?
I think it's, well, it's difficult, number one. I mean, there are so many interesting people on that court that I could have justified, I think, looking at Douglas. But I think it's fair to say that of the justices on the court at that time, Black and Frankfurter are the ones that have received the most attention. And you know, Douglas was a very influential and interesting jurist, but I don't think that he made a point of trying to explain his jurisprudence the way that Black did. And so I thought that it would make the most sense to look at both Frankfurter and Black because of their reputation, because they were also of interest to me, but also it was I decided to look at those three because Black and Frankfurter, as I argue in my book, represented certain regional traditions in American politics, which I argue was reflected in their particular constitutional jurisprudence. You had the Southerner Black, you had the Northeastern liberal Frankfurter, and they were, as I argue in my book, they were steeped in the political culture of their different regions. You had black, who was very much influenced by populism at the turn of the century. Then you had Frankfurter, who was very much involved and therefore influenced by the progressivism of the Northeast. So I thought that it was particularly useful to, it was a useful device to look at black as being emblematic of a populist kind of jurisprudence, and Frankfurter being emblematic of a kind of progressive jurisprudence, and then use that to try to figure out where Jackson fit in. And so what I concluded was that Jackson was, I think, a transitional figure. That is, that he harked back to the great common law attorneys of the 19th century, and was actually, I think, one of the last great common law attorneys on the Supreme Court. Again, which led to a complicated jurisprudence, one steeped in the facts of individual cases, which led to pragmatic decisions which drive academics crazy. But I think on the whole, what you end up with is a much sounder approach to constitutional issues, where you're very averse, skeptical of the kind of rationalistic approaches taken by his colleagues, Black and Frankfurter. Well, I can go back once again to their different approaches to the issue of incorporation, and that is...
Just for the purposes of the tape, incorporation, what do you mean by that?
Yeah, this refers to the area of constitutional law under the 14th Amendment, which has been used since starting in the 1920s, picking up steam in the decades thereafter, where the court started to incorporate, that is, to apply particular provisions of the Bill of Rights against the states, because originally the Bill of Rights applied only against the national government, and it was only with the ratification of the 14th Amendment that it became possible for the court to think about applying the different elements of the first 10 amendments against the states. And what you have with the New Deal justices, you have on the one hand Hugo Black, who argues that history demands that the justices apply all of the provisions against the states. They will apply not just against the national government anymore, but the framers of the 14th Amendment intended for the provisions of the Bill of Rights to apply against the states as well. On the other extreme, you have Frankfurter, who argues that they did not intend to apply the provisions of the Bill of Rights against the states, and you end up with a very passive approach to 14th Amendment jurisprudence in Frankfurter's decisions, where he is unwilling to hold the state governments to the same standards that the national government is held to under the Bill of Rights. And then you have Jackson in the middle, who argues, and this is actually the dominant approach that the Supreme Court has taken, which is, we'll apply the most important provisions of the Bill of Rights against the states, but not all of them. And so if you think about the implications of that, does it make sense to have all of the provisions of the Bill of Rights applied against the states? Black would say history demands it. The framers intended that to be the case. Number one, that's a very controversial argument to make. And number two, just from a policy perspective, if you think about the implications of that, and Black actually conceded this point, you have some provisions in the Bill of Rights which it doesn't make much sense for the states to have to adhere to them. For example, I believe it's in the 7th Amendment where it says that in civil cases above $20, that you have the right to a jury trial. So if you think about that, that means that any case involving $20 or more in this day and age, according to Black's argument, you can ask for a jury trial. And this would be enormously complicated and expensive for states to do. The other extreme, if you think about the implications of Frankfurter's jurisprudence, he basically says none of the Bill of Rights should be applied against the states. Really, the states should only be, state action should be invalidated only if you have an egregious violation that no reasonable person could think was constitutional. What that means is you have extraordinary deference on the part of the national government, or on the part of the courts, to state behavior. And again, if you think about the implications, what does that mean? Well, the argument that I try to make in class is that it's not unfair to suggest that in Frankfurter's jurisprudence that cruel and unusual punishment would be reasonable in certain instances, because if you think about the most heinous crime that you can, and then ask the question, would it be fair to torture a person who behaved in this way with such disregard for human life? And my students say, yeah, an eye for an eye. It's Old Testament morality. And then I ask, do you think that that's appropriate? And almost to a person, they say no. And so you've got the two extremes, Black and Frankfurter, and you're left with Jackson. There's two extremes which seem to be undesirable, and you're left with Jackson, who says it's more complicated, but what we should do is really take it case by case and determine if it makes sense for the court to apply particular aspects of the provisions of the Bill of Rights against the states. So more complicated, but I think on the whole much healthier approach to that particular issue.
And if you had to cite a couple of cases that Jackson was involved in where that was emblematic?
See, it's hard to call him pragmatic in any particular case. You have to have a kind of macro perspective where you're looking at all of his cases, where you can start to see that he's a much more complicated individual. If you just focus on any particular case, you don't get a sense of just how how pragmatic he is in the approach that he takes to complicated issues.
Would Korematsu be one of those where he just was really struggling with, in one sense, giving the executive a lot of leeway?
Oh, I see what you're saying. Yeah, in other words, is he obsessed over the facts of a particular case? And that I could say, well, any number of cases where Jackson is reciting the complexities of the situation before the court. Certainly his Brown working papers, where he just talk about obsessing. I mean, he's just very concerned about the factual situation before the court, the legal sources that are marshaled by one side, or by the respondents in that case. But the Korematsu decision, yes, I think you can also make the case that he's very attentive to the particular factual situation there. He pays a certain amount of respect to the argument of the government, and he says, I understand this is a very complicated situation, and it's very complicated for the judiciary to become involved in wartime matters. But Jackson ultimately says in that particular case that we have to, the majority, of course, didn't side with Jackson and the other two dissenters in that case. But Jackson essentially said, we cannot let this stand. Maybe you're right, but we don't know if you're right. There's no way for us to determine that, but we would be doing a disservice to the country if we were to write into constitutional law the kind of racial injustice that occurred in the relocation of Japanese Americans to inland detention centers. I believe he said at one point, I can't remember the case right now, it may be the Barnett decision, where he said, we act not by this is a rough paraphrase, we act not by the force of our competence, but because of our obligation to uphold the Constitution. Again, rough paraphrase. I wish I had it at the actual code at my fingertips, because it's characteristically Jackson. But I think that's quintessentially Jackson, where he is very aware of the deficiencies of the judicial process, which led Frankfurter to be incredibly passive. And Jackson said, we are deficient, but we still have a responsibility, and one that cannot be upheld by any other branch of government but ours.
As you today, this morning, focused in on Brown versus Board, is there an analysis to be had with just the Barnett case? You brought it up. Clearly, its phraseology throughout the decision is quoted over and over for a variety of reasons. And Republicans, Democrats, liberals, conservative, all take a piece of that. Is there analysis to be done of that case at some point? Because I'm not sure anyone's really done that case.
Oh yeah, I mean it's a beautiful decision, but it's also, especially in this day and age, where I don't think we think enough about what the concept of patriotism means. And I would argue that you have an incredibly healthy and very much American, classical American conception of what it means to be a patriot in Jackson's decision, which is basically this, that, and I would argue this goes back to the Declaration of Independence, that what is it that makes us American? It's our commitment to individual liberty. And what that means is the respect of other views, and that government should not be used to stifle dissenting opinions, even when it comes to issues as important as saluting an American flag. Because Jackson personally had nothing against participating in that kind of ceremony. And, but his point was, nobody should be able to force anybody to participate in that kind of activity. They should do it on their own out of love for their country and the belief that this is an appropriate expression of sentiment for one's country. His argument was that what we have here, what's competing in this case, is a profoundly felt religious belief on the part of the children involved here. And the appropriate thing to do in this case would be to respect their conviction that this is something that God demands that they not do.
It was interesting talking to the two sisters, Barnett sisters. We're very self-effacing and just solid Jehovah's Witness, and to them it's no big deal. They just did what they're taught to believe, and that was it. And frankly, very reluctant people to even talk about the case. But I never appreciated it until they talked about it. What the salute to the flag meant at the time. That, you know, we put our hand over our heart and we recite it. To them, it was hand over the heart, and ultimately the hand raises up. Very similar to what you saw on newsreels.
Ironic, isn't it?
Hitler. And when you listen to that, and you listen to their conversation about that, you'd say, huh. And that's what triggered their leader more than anything else, because the Jehovah's Witnesses were one of the first folks in Germany to be persecuted. And it starts all ties in. It's an interesting, almost a Nuremberg case before Nuremberg in 1940.
Yeah, I always thought that was ironic that the salute involved putting the arm out. It seemed particularly inappropriate at that time.
It's just fascinating. Going backwards a little bit, when Jackson was Solicitor General, he wrote a book entitled The Struggle for Judicial Supremacy, sort of an apologia for the court packing case. Then, ironically, becomes a justice of the Supreme Court. Having probably read that book and the criticism of the court at that time, did he live that criticism when he became a member of the court?
Well, it's funny, it's been a while since I looked at that book, but what I remember about it is it's generally regarded as a scathing indictment of the Supreme Court's behavior at the turn of the century, when, and what he focused on in particular was the invalidation of major planks of the New Deal. But if you look at that, I think it's especially in the early chapters of that book, he does not come out against judicial supremacy per se. That is, he makes the argument that the court's mission is to serve as a protector of the Constitution, that no other branch of government is in the position that the court is, given that these individuals are not only appointed to their positions, but they hold their positions for life. And he goes back to Alexander Hamilton in the 78th Federalist, where Hamilton says that if you don't have the institution of judicial review, if the court is not responsible for maintaining constitutional limitations, then the limitations imposed by the Constitution upon governmental power are for naught. And Jackson took that very seriously. I mean, he thought that what the court did at the turn of the century and into the early 20th century went too far, that what they were doing was crossing this line which is hard to define for him, but he argued that they crossed a line and engaged in judicial activism, whatever that might mean, and he argued that really that was inappropriate behavior on the part of the court. But Jackson had nothing against, after getting on the court, protecting constitutional liberties in cases that he believed where it was appropriate. Again, it's very hard to classify him. Frankfurter, Black, very easy to classify their approaches. Jackson was much more pragmatic, very much dependent upon the factual situation in the case before him, which I think goes back to his common law training as a lawyer in this area of the country.
Did he talk much, once he got on the court, I'm just trying to think of the oral history, I don't remember him mentioning much about the court packing case on reflection.
Yeah, the Columbia Oral History Project, yeah. I think there was. I seem to remember that there was a conversation about that. I don't think it was anything about which he was embarrassed. Mm-hmm. I'm trying to remember. I think that he, and feel free to edit this out, because I'm searching the recesses of my memory, but I think Jackson actually thought this was not a good idea, mm-hmm. that it was fated to fail. And he was right, if indeed that's what he said. But yeah, I mean, I'm pretty sure. I mean, that oral history was so complete. It was really helpful to me. So I'd be absolutely astounded if I went back and looked at my copies and didn't see anything about the court packing scheme. But maybe I fabricated what I just said.
I don't know. I'm just kind of intrigued by the whole book, 1940 book, because I'm not sure, and I asked Henry Abraham the same question, whether or not he was motivated to write the book because because of personal conviction, or one which was more of a justification of an action by his boss.
Yeah, and I should point out that as a member of the executive department, Jackson conceded that there were things that he did on behalf of the president with which he didn't agree. He felt that he was supposed to be the advocate, and so while he could advise against certain things once the decision was made, it was his role to defend the administration. And I think, again, I can't remember the case on the court. This was during oral argument. I think someone pointed out to him that as Attorney General, he had put forward a different argument, and he made the point that, well, as Attorney General, I'm fulfilling a different role, which is, I think, something very important for people to remember. When people get on the Supreme Court, they actually try to act like justices, and nobody more so than Jackson. They have their different approaches to what it means to be a justice, but it's a very different, I think it's oversimplified to say that they don't change and that you just have judges who are individuals implementing their value preferences. Though that's the dominant understanding in political science, I think it's wrong.
You're plowing ahead on this book, and inevitably as you're researching it, certain conceptions are being developed. When the day was done and you finally sent this off to Rowman and Littlefield, and you said, boy, that took a turn of which I did not expect in my research. Was there an area where you were surprised? I say, I would not have guessed that going into this, or when you put your initial outline together, you had to kind of change it?
Certainly the part in the book in which I talk about there not being a pre-Nuremberg and post-Nuremberg Jackson, because that meant I had to disagree with my with one of my dissertation advisors, and so that I had to think fairly carefully about. And but I remain convinced that Jackson was pretty much the same person after as before. The other, I wouldn't call this a twist, because when I began this, I really had no idea of how to explain the different approaches that each of these justices took to constitutional interpretation. So the whole thing, in a sense, was a surprise. I mean, the question I was trying to answer was, how do you end up with three justices who have served the same president and who were all united on the constitutional questions surrounding economic issues. That is, that the court should get out of the business of trying to determine the reasonableness of economic legislation. How could justices that were so alike in those respects end up with such incredibly divergent approaches when it came to the issues that confronted the court during the middle and the latter part of the 20th century? And so it was a real journey trying to figure out what it was that led these justices in such different directions. And the tack that I took was, again, fairly unconventional in political science, and saying that it's not just the values of the judges, though values do influence judicial decision making. I maintain, and there is a small group of, but growing group of scholars who make the same argument, that judges are much more complicated beings than that. That there is a sense, once you are elevated to the bench, especially the Supreme Court, that you have a certain obligation, a certain duty. And what is the duty? The duty is to act like a judge, to act like a justice. And what that means is you need to figure out some way to put your personal value preferences aside. And what you end up with these three justices are different ways of accomplishing that goal. And this is where their values, their backgrounds come in. They end up being attracted toward varying approaches to act like judges. But what I wanted to make sure my readers didn't overlook is that there's a certain commonality of behavior here, which is a deeply felt desire that as a judge one has a particular mission, and it's something other than simply writing one's value preferences into the Constitution.
What was the critiques of your book?
Of those who read it and bothered to comment on it, one was particularly frustrating because he missed my main point and said that what Hockett argues here, the grand insight of this book, is that the judges' values influence their decisions. And what he did was he looked at the one place where I say, obviously, their values influence their decisions. But, and then I went on and pointed out that what happens is those values pass through a lens, and the lens is, or a filter, and the filter is the judicial culture in this country, and that is that judges are supposed to act differently than legislators and executive officials. They are supposed to, as much as possible, base their decisions upon some kind of objective legal criteria. And so that was kind of frustrating to have a scholar overlook the main point of the book. Let's see. I can't put my finger on other major criticisms. I think certain scholars quibbled with the areas of jurisprudence that I chose upon which to focus. And especially with Jackson, I mean, there's so many interesting things you could focus on with him. And I chose First Amendment and incorporation because those were the areas of jurisprudence that Black and Frankfurter were most remembered for. And so I thought that was the natural area those are the natural areas that I should focus on to bring out what made Jackson special. And one person made the criticism that, well, you're leaving out Korematsu, you're leaving out Youngstown. And believe me, it was painful to do that. But what's nice is that I do have opportunities like this evening, or this afternoon, to talk about those cases and to offer my perspective on those incredibly important decisions. But there's no way I could have done everything, sure, because of 3 justices, and then you look at, say, 8 areas of jurisprudence, we're looking at several volumes. And there's no way the university presses or commercial presses are going to publish books that are that long. So
is that hard to do, just as from an author? You get your blood, sweat, and tears. How long did the book take?
That took me, I guess it was 7 years to complete. And also there's I think the thing that is most difficult is after you've written it and it goes out and then you learn more. You wish, boy, I wish I knew now or I wish I knew then what I know now. And so that's the most difficult thing about it. The blood, sweat, and tears, that's in a certain sense enjoyable. I actually like doing it. I wish I had more time to do it. Trying to make something that seems complicated understandable is a lot of fun. But it does get frustrating as you continue to learn more, to look back. And the thing that bothers me the most is that, and this is not entirely my fault, I have to say, that this perspective on the judiciary that I was trying to get across in this book, that judges are not simply their values. The school of thought of a certain small group of political scientists who make the argument that we need to focus more on the concept of an institutional mission, that it's a nebulous concept, it's very difficult to measure, and that's why political scientists are averse to thinking about it. But this is what we should think about, because this is actually a much more meaningful way of understanding judicial behavior. So if I had had that kind of awareness that this material was starting to appear in the literature, I discovered later on that there were some really important pieces that I just never had discovered. If I had those pieces of literature to crystallize the perspective that I was taking in this book, that it would have prevented that book from being misinterpreted and having somebody say, Hockett says the judge's values are their decisions. It's not at all what I was trying to say. So it would have been helpful to have a chapter where I could say, here's a really important piece in the American Political Science Review written by Roger Smith, who makes the case that judges, Supreme Court justices in particular, should be analyzed from the perspective that they each possess a particular sense of an institutional mission.
Was there specific things that you would like to have done an addendum to? Is that kind of what you're talking about here? Or?
To this particular work?
Yeah.
It would be nice to have an opportunity to look at those other aspects of Jackson's jurisprudence that I mentioned before. I mean, you think about the Korematsu decision, the Youngstown case, just to take two examples. That there are books, you could write a book on each of those decisions. So I don't know, perhaps when I'm completely through with this Brown project, go back to Jackson might make sense.
Would that be of interest to you? This book, and certainly some things you've written for the Supreme Court Historical Review, shows that you have an inclination more towards Jackson than others. Has he whetted your appetite enough to say there's more to learn?
Oh yeah, very much so. It's unfortunate that there are not more people working on Jackson, and if that continues to be the case, then maybe I'll feel even more of a pull to get back into working on Jackson. So yeah, I mean, it's definitely something that I will be thinking about, and the question is, can I conceptualize it in such a way that I can present it as something meaningful to a university press? Because as I think I alluded to earlier, it's becoming much more difficult to sell academic books to presses, and so there has to be some kind of feature that they find marketable. Which is why it's easy to write about Brown versus Board of Education. They see the relevance in that. It'll become much easier to sell a project on Jackson the more people know about him. So it's kind of a catch-22. You know, if I'm able to get more out, then it becomes easier. But until I do that, it's complicated to interest people in that. And I think it helped that I was contrasting him with two great, well-known justices, Frankfurter and Black.
Does the case which was not decided by this past Supreme Court, the Under God case, does that open the door for a conversation on a Barnett case? Is there enough similarities there?
That's a good question.
Because it's coming back in some form or fashion.
Yeah, they're not going to be able to escape it.
Sure.
I mean, essentially what you're asking is how would Jackson come down on this particular issue?
Well, yes, and also I'm also thinking the commercialization of a book. You know, what would be of interest to the university press? Certainly, that particular issue certainly galvanizes emotion, one way or the other, no question. You talk about salute, patriotism, rah-rah. And that grabbed it when the San Francisco court decided what they decided. So that's a grabber.
Yeah.
And if you then take that as the Supreme Court's going to be hearing that, and oh, by the way, the last time they really took on those, or at least one of the first times they took on that case, Caucasian and then Barnett, and clearly the Barnett decision is Jackson.
Right.
Hence, drum roll Jackson. So is that
Yeah,
a normal bridge?
I think people would find real food for thought in Jackson's opinion when we're talking about that contemporary issue. And I mean, it's kind of a cheat to make an argument this is how Jackson would have decided this case, because we actually don't know. But having said that, there are aspects of Jackson's opinions dealing with religion, freedom of thought, that I think are going to give solace to those on maybe both sides of the issue. But I would argue that given Jackson's background and his writings on his religious makeup, his background growing up in this part of the country, that I have to believe that he would be very averse to those who want to use the classroom to inculcate particular religious beliefs, the public school classroom, to inculcate religious beliefs. It's not to say, and this is where you need to be careful about interpreting Jackson's position on this kind of issue, he's not anti-religious. The argument would be this is very much a personal matter. It's something to be relegated to the private realm, and it's up to parents, it's up to family members to figure out how best to train their children in religious matters. And I think he was very hesitant, reluctant to allow government to have a role in that part of our lives. I don't think he would have had much sympathy for what I think is fairly classified as a conservative position, that the health of the republic demands that government become involved in this aspect of our lives. I think that he thought that was not only wrong, but actually very dangerous to individual liberty.
Your friend Raul Schiller, this is one of your criticisms here, the critiques of the book rather, and talks about this.
What is this from?
This is Law and History Review, the book review.
Oh yeah, it's been a while since I read that.
Anyways, University of California, Hastings. Anyways, it was positive, but said you wouldn't have been great to cover other factors that may have influenced Black, Frankfurter, and Jackson in the decision making, such as decisions were shaped by many factors, including the justices' reactions to European totalitarianism, McCarthyism, and racism, or their desire to maintain institutional integrity of the court, for example. If you had the chance to think about those particular factors, which this reviewer says, gee, it would have been nice to have those brought in, what would you say, for example, how much did McCarthyism that was going on in the late 40s, early 50s,
Yeah, I don't want to be too harsh on a critic, because then it seems like sour grapes. I appreciate all kinds of thoughtful commentary, but do I feel that the analysis was insufficient and that I didn't pay attention to that sort of thing? I would argue no. I actually, though justices are very much aware of these important events in American politics, I don't think. What I was after here is, okay, what are the guiding principles of the constitutional jurisprudence of each man? And I think it would be inaccurate to draw attention to specific incidents like that and say, this is what explains someone like Jackson, this is what explains someone like Black. I think that Jackson's jurisprudence was full-formed before that particular event. And then, there's nothing more cataclysmic than the Nuremberg trials. And even there, I try to point out that he was pretty much the same justice before or after as before. And this goes back to my understanding of what motivates justices. Now, I'm obviously not saying this motivates every justice, but we're looking at what are the primary motivations for justices, and I think it's accurate to say that what motivates them is they try to develop a sense of what it means to be a justice, and that means to put aside one's personal value preferences. So you end up with Black, who argues, I need to follow the framers' intentions. And he was very sincere about that. I mean, some of his history was controversial, fairly weak, but I think that he really was sincere in that he thought, to be a justice, I have to put my personal values aside. His personal values did influence his approach, that as someone profoundly influenced by the populism of the South, it didn't pain him to conclude that in following the framers' intentions, that the judiciary needed to be very aggressive in protecting certain rights, like First Amendment rights, for example. But the point that I want to emphasize is that in many instances, Justice Black decided cases against his own personal values. Witness the Griswold, the Griswold decision, where he chastises his colleagues for writing a right to personal privacy into the Constitution. He says, I like my privacy as much as the next, but I can't do it because there's no legal basis upon which to do this. Frankfurter did the same thing. I mean, if you look at Frankfurter's background before he came on the Supreme Court, he was very much a political liberal. Yet he ends up time and again rendering what can only be characterized as conservative-leaning decisions. Why? Well, again, his values did influence him. He came from a progressive tradition. The progressives argued that society is incredibly complicated and interdependent, and the judiciary is a flawed institution, that it actually cannot understand the complexity of society. So Frankfurter ends up hanging back in cases, not using judicial review in cases where he really wanted to use it. Witness the, I believe it was a death penalty case where, maybe you can remind me of the name of the case. It's the one where a state tries to execute a young man, fails, and then ends up trying to execute him again, and it comes before the Supreme Court. And Frankfurter says, this really pains me because I think this is barbaric behavior on the part of the state. But the question is not, what do I personally believe? It's, is there anything in the Constitution to prevent the state from taking another shot at this individual? And so he stays his hand there. And I think it's cynical to say, well, this is just a cover for Frankfurter's values. He really did want the state to be allowed to do this. That I don't agree with. But the same thing with Jackson. I mean, Jackson was not simply someone who attempted to write his values into the document. I think it's safe to say that there are instances in which personally he reached a decision that conflicted with his values. It probably pained him to rule against Truman in Youngstown. But his argument was, my mission is to uphold constitutional limitations, and in this instance, we need to pay attention to the limitations imposed upon executive power, which, by the way, still hold during wartime.
Is that concurring opinion deemed to be the most effective word from the court as far as the limitation on executive powers?
It's certainly oftentimes cited. I'm not convinced it's read carefully enough. Because usually what people focus on in Jackson's Youngstown concurrence is this, at the beginning of his opinion, he talks about 3 different situations in which the executive acts. One in which he acts with the consent of Congress, which means he has not just his own powers, constitutional powers, but Congress on his side. And then you have a twilight zone where if Congress has taken no action, he only can act on the basis of his own constitutional powers. And then the most controversial, which is where he acts contrary to the will of Congress. Because there it's his powers against Congress's. And that's what everybody focuses on. But if you read through the rest of the opinion, I think what you end up with, and this is one of the messages of my talk this afternoon, is that you get a very clear discussion of the importance of imposing and maintaining limitations upon executive power even during wartime. And what I'm going to try to do this afternoon is to link him with James Madison on this issue, that war is not an excuse for liberating executives from constitutional limitations. So it's that part of the opinion that I think is overlooked oftentimes, and they end up, it's not to say that the part where he categorizes executive behavior is unimportant. It's very useful. In fact, I think Chief Justice Rehnquist in certain talks has emphasized how useful that distinction that Jackson draws is. But I would argue that the most meaningful part of that opinion is where he gets down to brass tacks and talks about, he goes through all of the government's arguments, Truman's arguments for seizing the steel mills, and points out that none of these justifications holds.
Any shocker when you went through the Jackson papers and said, oh my God, I had no idea?
Well, yeah, I think I may be repeating myself, but the whole thing was just eye-opening, given that I knew so little about Jackson beforehand. I mean, he's just such an interesting man. To take out his files dealing with Nuremberg, to take out his working papers on the Brown decision. I guess if I had to, if you really insisted, I would probably say his Brown memos, because the approach that he initially thought he was going to take in that case was so different from what the court ultimately did. Because Warren ends up focusing on the harms of segregation, whereas Jackson is arguing, no, we need to strike at the root, which is an irrational belief in racial inferiority. That was, I think, it would have been a really gutsy move on the part of the court. But I was really struck when I came across these working papers, because he really had thought this out very carefully and went through a number of drafts on that. And it's such an interesting take on that case.
Switching gears completely. You have one of your students who is a clerk with Chief Justice Rehnquist.
Mm-hmm.
And though we talked a little bit about it before, and I asked Henry Abraham when he was here at this particular seat a year ago, to name names as far as potential replacements for judges, and he gave me names, and I won't tell you what they were, but because time has changed even since he was here in March of 2003. I mean, you talk about 18 months ago.
Right.
The landscape has changed, and guys like Gonzalez and Estrada that seemed maybe towards the top of the list.
Yeah, no way now.
Exactly. In your world, since you have an opportunity to read probably more than normal folks in the judicial world.
Now, you have to understand just how isolated we are from the powers that be.
And I recognize it's politics, but at the same time, you got to have a sort of.
And I guess I should preface this by quoting Lawrence Tribe, who I think once said, "Those who live by the crystal ball tend to eat a lot of ground glass."
But give it a shot. We may have up to 4 justices in the next couple of years. And I realize, depending on the party, so if there was a Republican, do you have a sense of a top 2 or 3 that?
I'll give you a top 1, and that I think it would be J. Harvey Wilkinson, who is, I believe, an appeals court judge right now, and I think it would actually be smart if Bush is reelected for him to appoint someone like Wilkinson, because he's not only cerebral and very smart and has a judicial record, but he's also fairly moderate. Certainly not when you look at it from a left-wing perspective, but as divided as we are, I mean, Wilkinson is, I think, to many considered a fairly moderate conservative, and very thoughtful. So it'd be very hard, I think, for, even if the Democrats retake the Senate, it'd be very hard for them to turn down somebody like that. Kerry, I don't know. I mean, I'll tell you, the shrewd political move would be to appoint Hillary Clinton, right, to take care of competition from that part of the party. But I don't know, look for who he makes Solicitor General or Attorney General. But I hate to disappoint you, but I really am at a loss. I think Kerry's been very tight-lipped about his, about the Supreme Court. Sadly, the Supreme Court has gotten very little attention during this election, and I wish that the press had pushed them more on this, because we probably would have had more indications about who they're thinking of appointing. What were Abraham's guesses?
He just felt that an Hispanic would almost have to be the first choice, and then he broke, once you're into that category.
You mean for both parties, for either? Yeah.
Whereas at the time we weren't focusing in on the election.
Right.
But it was, he had 3 or 4, Gonzalez Estrada, 2 other people that he mentioned, names I've forgotten. But he was thinking that segment had to be dealt with, Hispanic.
As you said, certain of those names are no longer possibilities.
That's right. Henry, who was your, in some senses, your mentor, one of your mentors down at the University of Virginia, his comment on the book, did he talk to you about it?
No. Yeah, I don't think I've ever received, I mean, he's been complimentary, but I don't think, I don't recall any kind of substantive commentary. And I think that Mr. Abraham would say it's, well, just because I was on your dissertation committee. This is actually much different than my dissertation. It's significantly different than that. I did, before this book came out, I did an article in which I compared and contrasted the constitutional jurisprudence of Frankfurter and Black, who are not central to the dissertation. And I'm pretty convinced, given the phraseology of the reader, and the readers are anonymous, so I'm not given the names, but it was very much Henry Abraham's language. And so it was a very positive assessment from the reader. And so if it was Henry Abraham, then he found it to be a convincing argument. So I took that as a good sign. So.
Who do you look towards? In your world of academia, are there 2 or 3 scholars that you say, they got it right? And you look to their next writings.
Contemporary scholars?
Yeah.
There's a guy at the University of Southern California who's about the same age as me, who is going to be, and if he hasn't already, I would argue he has already, make a real name for himself, and that is Howard Gilman. He wrote an incredibly important book, The Constitution Besieged, where he makes the argument that the turn-of-the-century Supreme Court, contrary to conventional wisdom, and conventional wisdom is, again, that they were simply writing conservative laissez-faire economic principles into the Constitution. His argument is that is wrong. Again, it's the same perspective that I'm using in my work, which is judges are much more complicated beings than that. And his argument is this wasn't simply judges writing laissez-faire values into the Constitution, because if you look at the decision-making at that time, it was much more pragmatic than people realize. They were not hardcore conservatives. They were not absolutely opposed to economic regulation. In fact, they upheld quite a bit of regulation, which leads to the question, all right, well, what was motivating them then? And what he argues, and I should point out Gilman is part of a group of scholars who have looked more carefully at this period in the court's history, but his book is actually an award-winning book. I believe it won an award from the American Political Science Association, where he argues that what these justices were trying to do was what I had said earlier, that is, they're trying to be judges, and they're trying to engage in much more principled decision-making than we realize. And what was motivating them was they were trying to figure out how to distinguish between unreasonable and reasonable forms of legislation, unreasonable being those that served to exacerbate class conflict in this country, that if you had legislation that was simply trying to reward one class at the expense of another, then we were asking for trouble. And so their mission at that time, they thought, was to prevent this kind of legislation from coming into being, because the Constitution does not stand for one part of society being put above another at the expense of that other part of society. So I look forward to his work. He's a very smart individual, has made a real contribution, I think, and given that he's so young, I suspect that down the road he's going to end up making a huge name for himself, again, if he hasn't already. And then Gerald Rosenberg, I also think I have a lot of respect for his work. And I'm mentioning 2 people that I've brought out to TU to talk to my students and to the public. Gerald Rosenberg another young scholar who wrote an incredibly important book on the impact of Supreme Court decisions entitled The Hollow Hope, Can Courts Bring About Social Change? ? And his answer is basically no. And he takes a very interesting position. Much of the book is focused on the Brown decision, and he puts forth the incredibly controversial argument for which he provides an enormous amount of empirical evidence that the Brown decision actually did not have the effect, either direct or indirect, that people think that it did. And it's just really thrown people for a loop, because what he's doing is challenging the life's work of many, many people who are assuming that the decision has had this enormous impact. And I actually enjoy this because it challenges my deeply held beliefs, which is that Brown actually did have a significant impact in American politics. And to be told, here's the evidence, it looks like you're wrong. I don't know if fun is the right word, but it's a really interesting exercise to present this in class and say, okay, does this hold up? But I have a lot of respect for people who are willing to make an argument like that, where they know that they're going to be attacked, and vigorously, and he was, and is. So.
This has been terrific. Just terrific, Jeff. I really enjoyed this.
I appreciate it too. It's a lot of fun. As I said, it's been a while since I had an opportunity to think about Jackson, and this has given me an opportunity this afternoon in particular to talk about something that I wasn't able to talk about in my research, but which I think is really relevant today, particularly Jackson's views on executive power. So I appreciate it.